All right, let's talk about something incredibly important, something that really impacts workplaces all across Australia: harassment and assault. Figuring out where the lines are drawn isn't just a nice to know. It is absolutely critical if we want to create a safe, respectful environment for everybody. And just to give you a sense of the scale we're talking about, look at this number. It comes from the Australian Human Rights Commission: 1 in 3 people. That's not some rare, isolated incident. This is a huge, systemic issue, and that's exactly why we need to get our heads around it.
So here's how we're going to break it all down. First, we'll look at how the legal ground is shifting. Then we'll get into the crucial difference between harassment and assault. After that, we'll walk through a real-world case, see the court's final word, and wrap up with what is now legally required of every single employer.
Okay, first up, things have changed. We're going to explore how Australian law has really moved on from just reacting to bad situations. Now it's all about demanding that employers get out in front and actively prevent them from happening in the first place.
Now, let's get to the absolute core of this. You hear the words harassment and assault thrown around, and sometimes people use them interchangeably. But here's the thing. In the eyes of the law, they are worlds apart. And knowing that difference is so important.
And you can see just how different they are right here. Sexual harassment? That's a civil matter. It's handled in places like workplace commissions. The standard of proof is what's called the balance of probabilities, which basically means, is it more likely than not that this happened? But sexual assault, that's a whole different ballgame. It's a criminal offense. We're talking police and courts, and the proof has to be beyond a reasonable doubt. A much higher legal mountain to climb.
Let's zero in on sexual harassment for a second. The magic word here is unwelcome. That's the key. It could be a one-off comment or a pattern of behavior that builds over time. And here is the absolute kicker. It doesn't matter what the perpetrator intended. What matters is the impact on the person, and whether a reasonable person would look at that conduct and think, yeah, that's offensive, humiliating, or intimidating.
Sexual assault, on the other hand, is defined very differently. It's any sexual act done to someone without their consent. Full stop. This isn't a workplace relations issue for HR to sort out. It's a crime. It needs to be reported to the police, and it's prosecuted by them.
So, theory is one thing, right? To really see how these ideas work in the real world, let's look at a recent and really revealing case. This story doesn't just help define harassment, it's also a powerful lesson in the serious consequences for employers who get the response to a complaint completely wrong.
So, the case involves an employee, a Miss Taylor, and the director of the jewelry company where she worked. She came forward and said that over a period of years, she was the target of a pattern of behavior that went way over the line.
And this case really shows how harassment is often about the whole picture, the context. It wasn't just one single event. It was this building pattern. We're talking 19 separate gifts of jewelry, inappropriate comments about how she looked, unwanted declarations of romantic feelings, and even being physically slapped on the buttocks. All of that together created this really intimidating environment for her.
Okay, and this is where a bad situation got so much worse. After Ms. Taylor finally made a formal complaint through her lawyers, what do you think the director did? Did he investigate? Apologize? No. Instead, he went on the attack. He responded aggressively, he demanded she return all the gifts, and he even threatened to get the police involved against her. This reaction, well, it spun off into its own separate legal problem.
The court looked at everything and found that the combination of the original harassment and that hostile response, which, by the way, has a legal name, victimization, had a direct and devastating impact on Miss Taylor's health. It led to her developing serious, diagnosed psychiatric conditions.
So, after all that, what did the court have to say? Well, the final word was a landmark ruling, and it sent a very clear and very expensive message to employers everywhere.
The court awarded Miss Taylor more than $250,000 in damages. I mean, just look at that number. It really drives home the massive financial risk for any business that fails to keep its people safe.
And when you break that number down, it's pretty eye-opening. She got $140,000 for the harassment itself. But then she got a separate $40,000 just for the victimization, for that awful, aggressive response. And then look at this. Another $15,000 in what's called aggravated damages. That was awarded specifically because the employer just completely failed to even acknowledge the toxic environment they'd created. So the lessons from this case are crystal clear. First, harassment is all about the context, the whole story. Second, how you respond to a complaint is absolutely critical. It can literally become its own legal nightmare. And third, courts are taking psychological injury very seriously and awarding major damages for it.
You know, this case is the perfect example of a huge legal shift that's now affecting every single workplace in Australia. It's called the positive duty, and what it means is that employers have to stop just reacting to incidents and start proactively preventing them from ever happening.
So what does this positive duty actually look like on the ground? Well, it means leadership has to walk the talk and set the standard for respectful behavior. It means you need solid policies and regular training, not just a one-off. It means you have to actually look for risks before they turn into problems, and maybe most importantly, you have to create safe, clear ways for people to raise concerns without being afraid of backlash.
And that really leaves us with one final big question to think about. Whether you're a CEO, a manager, or part of a team, take a hard look at your own workplace. Is the culture truly built around preventing harm before it starts? Or is it just sitting back, waiting to react after something terrible has already gone wrong? Because the answer to that question has never been more important.